I am a former NAMI family member, and I got so much out of that opportunity. I can't thank you all enough for the support I got, so thank you. But now I'm going to turn that hat around and become an ERPO advocate and explain to you how this works. First of all, you'll notice that it says ERFPO, which is technically the correct name for it, but nobody ever calls it that. So I'm just going to keep calling it ERPO. It's the Extreme Risk Firearm Protection Order. And today what we're going to talk about is how they work and why you should care. Okay, let's start with when do you get one of these things? I'm going to say this repeatedly because it's so important. This is an emergency measure. This is not something that you can use if you have a family member who has a long-standing mental health diagnosis and every day looks the same, challenging for you, but looks the same, and they have a gun. That won't trigger it. There has to be an emergency or a trigger. I hate to use the word trigger, but a triggering event that makes you think right now is the time I need to get this. And it's so urgent because this is going to start this court process without the person who owns the gun, who we're going to call the respondent, the person named in the petition, without the respondent even knowing it's happening. It starts before they get notice. So what is it? An ERPO is a civil order, and it temporarily prohibits somebody from possessing or purchasing a firearm. And it's two very important factors. The court has to find that somebody poses a significant danger. So it can't be like they just seem different or they're talking louder or whatever their symptoms are. That's just not going to be enough. It has to really be something that suggests there's a significant danger of harm to self or others. And frankly, that's most likely going to be harm to self. You're most likely to see that. But that doesn't mean that it can't happen, as we know. We've seen other kinds of crises that end in tragedy with the use of a gun. So it has to be significant, and it has to be so urgent that a court will engage in this process before the person even knows about it. A lot of people are used to seeing domestic violence orders of protection, and they kind of look quite a bit alike, but they do have a lot of sort of legal mumbo jumbo differences. And I don't really want to go over the differences, but I want to help you figure out, if you are a family member who thinks that they may also have a domestic violence situation, which one do I want? Do I want an ERPO or domestic violence order protection? We're going to get that cleared up for you. So one thing that it's difficult for people to understand is that the court isn't going to just grant it. The court is required to find that the action needs to be taken by probable cause. Probable cause is one of those standards of proof that's amorphous, but when you put it in context, it's understandable. Our highest level is beyond a reasonable doubt. That's for criminal cases. Sometimes we have by clear and convincing evidence. Probable cause kind of falls in the middle, and it means, is it more probable or not than not that this is true? So if the evidence in front of the judge is 50-50, the judge is not going to issue the order. But if the judge feels that the evidence is 50 plus 1, tiny bit more, that's probable cause, more probable than not. So what they have to find is what we've been talking about, that there's significant danger, that immediate action needs to be taken before the person gets notice. There are a lot of people involved in this process, and the process starts with the reporting party. And I picked this image because I think this is what people think it looks like to be a reporting party. A helpless, hopeless child in a not very round rock that you have to push across. It's not that hard. The reporting party has a very important role, but it's simplified. Anyone can do it. So who can be a reporting party? Well, here's a picture of a happy family, sort of. I think the dad is looking at the mom with kind of a weird look, but that's just me. So reporting parties are listed in the statute the same as they are listed in the domestic violence order of protection. You'll recognize all these people. It's spouses, former spouses, every kind of relative you can possibly think of. And in New Mexico, our Family Violence Protection Act also includes girlfriends and boyfriends, which is not something that's universal. It's not in our federal statute, but it recognizes the reality that people don't get married as much, but they still get into very complicated relationships. So girlfriend and boyfriend works. So those are the reporting parties that are listed in the statute. And then they name two other ones, a school official and an employer. By legal definition, we don't know who the heck those folks are. It's not that clear what a school official is, and it's not that clear how much it takes to be somebody's employer, excuse me. It's really kind of vague, those terms. And normally I would say, let's dive into who can be a school official and who can be an employer, but we don't have to. And the reason is the way this statute was written. It was designed to confuse everyone, because any person who reads like a normal person reads would believe that it says a reporting party includes and then names all these people. And that means those are the people who can be reporting parties. But the word includes is magic. It has its own set of definitions. And what it means is includes but is not limited to. And there's tons of case law about this. You know, I've talked to other lawyers and they said, no, it's just those people on the list. And it's like, no, it's not just those people on the list. We have other statutes that have lists of people. And when the word includes is there, it means includes but is not limited to. Yet, they still think I'm wrong. So a very nice judge went ahead and asked the Attorney General's office to please say, in the context of this statute, what does it mean? And it means includes but is not limited to. So no matter how many times a police officer or somebody who thinks they can read a statute tells you what it says, you now know the secret word is includes. Why is this important? Because it means everybody on the planet Earth can be a reporting party. If you are the person who has the information, you can be the reporting party. There is no other statute in the country that's that wide open. So we have a very broad statute. I happen to know for a fact no one intended it to be that broad. It was a drafting error, but it is what it is. And until somebody changes it, it means everybody on the planet Earth. And that's really important, because let's think about some people who might really want it. It might be a therapist who has the information. It might be a next door neighbor. It might be a police officer. If he has independent knowledge, that he knows, like he sees something happening and he thinks, the guy hasn't committed a crime, but he's clearly not himself. I know this guy from the street. I've seen him. This is different. And he has access to a firearm. That police officer can go, even though it doesn't look like it, because what police officers are labeled in this thing are petitioners. Okay, what does the petitioner do? The petitioner is the one who really carries a heavy load. And the petitioner in the statute is very clearly labeled. It can either be a district attorney's office, all these folks put together, or a law enforcement officer. I've done this training for lots of law enforcement officers and practically every DA in the state, and I will do it again for them, because even they don't believe, they don't believe that the petitioner includes everyone on the planet Earth. And they also, the DAs didn't believe they had to do this. And I was the bearer of bad news. As much as you think you have a big caseload, I'm adding more. The good news is it doesn't come up that much. Anybody who tells you, oh, the sky will fall because we have an ERPO statute is just blowing smoke. It comes up very rarely because it's so narrowly defined. It has to be an emergency. It has to be something that suggests danger, not just difference. So it has not been used a lot. So how do you decide? What do I want to do? Do I want to go to the district attorney's office or do I want to go to law enforcement? Let's see what they do, and then that will help you decide where you want to go. So the petitioner gathers the information from the reporting party. We'll call this reporting party the next door neighbor. Next door neighbor says, I've known this guy my whole life. He's different. And I see him carrying many more guns into his house than I've ever seen before. Something's wrong. So he could tell this to a DA. He could tell this to a law enforcement officer. Both of them are good at taking reports. That's what they do. So far, so good. Both of them are good at it. Then somebody has to prepare the affidavit for the reporting party. That's a piece of paper that says what the person said. The good news is it's a form. It doesn't take rocket science to prepare this affidavit. You're just going to check the boxes. So I would say both a district attorney and a law enforcement are equally good at checking boxes. They ensure that it's notarized. Well, maybe a lawyer would take a little more time to make sure, but if it's not notarized, the court will make sure it gets notarized before it gets filed. Then they prepare the emergency petition. Same thing, it's a form. It doesn't take rocket science to check off the boxes. When we say prepare the emergency petition, what that means is a court very rarely generates a piece of paper. Somebody comes in with a piece of paper and says, please sign this, Your Honor. Here's a draft emergency petition. I've checked all the boxes for you. Just put your name on it. So that's what the emergency petition is going to look like. It's going to be a form that you're going to ask the judge to sign. This person has to file the petition. Okay, I'm going to put it in the category of lawyer, probably is better at filing things than law enforcement officer, but argues the case. This is where the rubber meets the road. Somebody has to convince this judge that the person who reported was reliable and that the information qualifies, enables the judge to authorize the issuance of the order. A law enforcement officer might feel he's good at it, but frankly, I believe lawyers are better at it. They're better at explaining to judges what the facts mean. They're better at trying to help the judge understand where they have to go. So my recommendation, it's just a recommendation, is I would go to the DA's office. If you live in this judicial district, I would definitely recommend going to the DA's office, not because the law enforcement officers, not because the city police wouldn't do it, because they would, they're on board. But I've done a training with those ADAs, and they're really on board. If you call up and you say, I want to talk to somebody about an ERPO, they'll know what you're talking about. You won't feel crazy when you do that. After everybody goes to court, remember the respondent, the person who owns the guns, is not in court yet. This is all done ex parte. So somebody has to tell them, because there's going to be a hearing within 10 days. The last thing that has to happen is we need support for the reporting parties. And you'll see that this DA's office has an investigator and an advocate. That advocate has experience working with people who are agitated, frightened, not used to working in the legal system. They have the ability to help that person, the reporting party, get through the process. So that's my recommendation, but both options are available. Then we're going to have the 10-day hearing. The person who was the petitioner, the law enforcement officer, or the DA has to show up 10 days later. Okay, so what's the result of an ERPO? It's a temporary order followed by a final order prohibiting possession of all firearms. When we say final order, it doesn't mean for the rest of their life. It means for 1 year. The temporary order is the one that gets them from day 1 to day 10. Okay? The final order can change over time, even within that year. If the person, the respondent, feels that some respondents might feel they don't want to have a gun, and then later on feel like, I am in a position to have my firearm back. They can go in at any time during the year and ask and petition the court to get it back. So even though it says final order, not so final. What it requires the respondent to do is relinquish their firearms within 48 hours of service. After the court issues the order, police officer or the DA or a process server for one of them has to go to the respondent's house and tell him about this. At that time, they're telling the person, you need to relinquish your firearms at the police station within 48 hours from right now, from when I'm standing in front of your door. Everybody knows that somebody who owns guns and is in an agitated mental state is not going to be happy about this knock on the door. This is not going to be an easy thing for them to be told that somebody went behind their back, talked about them, and now they have to give up their guns. So there's a high possibility that they will not give up their guns. They'll say, yeah, sure, I'll be there in 48 hours. Bye. So does that mean this whole law is stupid and it doesn't do anything? No. There are ways to get this enforced, which I will share with you. But before we go there, let's figure out, how is the court going to decide whether or not to issue this ERPO? What can the court consider? Tons of things. And they're things that you probably expect. Even though the court has to look at the emergency nature of it, the immediacy of it, they will look at a history of mental health if they see that somebody has a long documented history of mental health issues. The most important thing that they're going to look at, I believe, is the recent acquisition of more guns. Somebody can have a gun and have a mental health disorder and just be perfectly fine. There's no worry there whatsoever. But when you start to see people starting to stockpile and they're getting more and more agitated, that's a big sign. So they're going to look at these various pieces of information. Those are the pieces of information that are on that form that the person is checking off. And then, of course, there's a little place to explain it all. There's one in particular, the one down here in the bottom right corner, which says, any lawsuit, complaint, petition, restraining order, injunction, anything going on between these two people, the judge can take a look at it. So we're going to ask you to be the judge. How are you going to look at the fact that these two people are in a domestic violence relationship, or these two people have been fighting over a fence for years and are both really agitated about it? Some judges are going to see this bringing of the petition, the ERPO petition, as a tactic. You're just trying to get at this guy. You have this divorce going, you hate him, you want to get his guns away from him, you want to, to him. That's one way of looking at it. Another way of looking at it is to say, when somebody files for a divorce or somebody leaves a domestic violence situation, the danger is up to 1,000%. Well, literally 7 times more likely that someone will get killed. So the fact that there is litigation going can really be viewed in two very different ways. And that's why I think it's so important for a district attorney to understand that they have to explain to the judge, this isn't a tactic to hurt the other person. This is an attempt to keep this woman and her children alive, Judge. Things got much worse on the day she filed those divorce papers, and she knows it and he knows it. And so do you, Judge. So that's one of the most important issues we have to get the judges to understand. When somebody goes in for a domestic violence order of protection, there are a ton of things for the judge to look at. Just every kind of, well, some of them are crimes, which are not required for an ERPO. Nobody has to show that somebody committed a crime. But some of them are really terrible crimes, stalking and sexual assault, threats, phone harassment. There's lots and lots of things for somebody to look at if they need for a domestic violence protection order. But because there are so many things to look at, the judge is deciding many more things in a domestic violence protection order. They have to decide who stays in the house. They have to order them to have no contact. They have to figure out how are they going to share the kids. Who's going to support it and you cannot destroy any of the community property once an order of protection is issued. You can't go sell your wife's car and say, ha ha, no can do. So there's a lot of things for the judge to come up with. So they cover different kinds of problems in people's lives, even though they both are about relinquishing firearm orders, because our domestic violence statute was amended a few years ago and has this exact same language, that if you come into court and you want a domestic violence order of protection, you can ask for all kinds of things. Can you order some payment to me in the interim? Can you tell me when the kids have to go see him? Can you require him to relinquish his firearm? That is part of our law and the domestic violence statute. And it's also part of our federal law. People who are under an order of protection, a domestic violence order of protection, may not own a firearm. They have to relinquish it. So if both of them involve relinquishment, how are you going to decide what you want? They seem pretty similar. The answer is, what do you want? Do you want to have all those other things decided because you're in that kind of a relationship, a domestic violence relationship? Or do you simply want to talk about this gun or these guns? If you just want the guns, I say go for an ERPO. If you are concerned about guns and you have a domestic violence order of protection that you need to, and you have a family violence protection order that you want, you can ask for it there. My experience is judges never require relinquishment in the DV context. They'll, we'll settle this, house, who stays in the house, who gets the kids on Saturday. We'll settle all these issues, but I'm not going to touch the gun. It's just a practice. So if you're not going to get satisfaction after you get your order, you go in and you ask for your domestic violence order of protection, and the judge says, I'm not going to order relinquishment of the gun. You can then file an ERPO and say, I want to tell you why I need relinquishment of the gun. We had a lot of things to discuss before. I have something specific I want to bring. People say, well, why don't I just do them both at the same time? The answer is judges don't like two things. They can barely handle one. So do one at a time. If you get the result you want, go ahead and be done with it. If you don't, go ahead and file an ERPO. In both of them, it's the same thing. Relinquishment is not the same as seizure. These laws do not authorize police officers to go in and take a gun. So how do we do this? Is there a way that a police officer can just seize it pursuant to a warrant? And the answer is yes. Because if somebody does not follow a court order, they are committing a crime. Failure to meet a court order is contempt of court, and it's a crime. And if somebody has committed a crime, a police officer can go get a search warrant for evidence to support that crime. And the crime was you were supposed to relinquish your firearm and you didn't do it. So the evidence that I want to get is going to be the firearms. So that's one way to do it. It's kind of clunky, but it's doable. All the police officer has to do is go into court and say he has probable cause to believe that a criminal offense has been committed. Hold on, I have to close the door 1 second. I'm sure you don't want to hear my wife talking to the dog. Okay. But what about if he doesn't want to get a search warrant? When can he seize a firearm that's in plain view? First, we have to figure out what plain view is. Plain view means the officer sees evidence of a crime that on its face is clearly evidence of a crime. If it's a piece of paper, maybe on its face it's not clearly evident. But if it's a gun that this person shouldn't have, or if it's a syringe that this person, whatever it is that's clearly evidence of a crime, that's the first criteria. And it has to be in plain view for the officer from a place where he can see it. Okay. So sometimes a police officer will come to the house and say to the person, would you like to relinquish your guns right now? Let's go down to the police station right now. And sometimes they will. People have done that. Sometimes the police officer says, may I enter your house? If the person says yes, and the police officer sees guns, he can say, you know, you're not allowed to have these guns. Do you want me to take them? I can seize them, or you can turn them in. That's all well and good. But if the police officer doesn't have permission to enter either a residence or a vehicle, he cannot seize the evidence. He has to be in a place where he has permission to be. So we already talked about sometimes people just consent to turning in their guns. Sometimes they consent to a search. When does that happen? Have you ever been stopped by the police and the police officer says, mind if I look in your car? There are very, very few people who say, yeah, I do mind, don't do it. I don't want you in my car. I would have a hard time doing it, and I know that's the law. It's tricky to say to a police officer, I don't want you to look in my car. And many people who know they have evidence of a crime in a car consent with the following theory. If I say he can look in my car, I'll look less guilty. And he'll just say to me, I was just testing you. I just wanted to see what your response was going to be. Never mind, I don't have to go into your car. That has never happened in the history of the world. If somebody says you can search my car, they're going to search your car. That's it. So lots of times people consent. So that's one way that the police officer can find it. Maybe there is a traffic incident, or they stop them for some legitimate reason. They have a valid reason for being there. They can ask for consent, or they could have a warrant. But the third category is exigent circumstances. Exigent circumstances is legal nonsense for something big is happening right now. I don't have time to chit chat about this. Right now, I need to get this gun. So it has to be immediate. It has to be dangerous. So how do we know when a police officer has exigent circumstances? What are exigent circumstances? The facts supporting the ERPO. If a judge ruled that you are entitled to an ERPO, they found immediate danger, high risk. It's done. That is exigent circumstances. So if a police officer has his ERPO in his hand, he can seize the evidence that's in plain view because it's exigent circumstances, even though it's in somebody's house or in their car, which are more highly protected than, I don't know, you're somewhere else. Okay? So that's Law 101. You now know probable, preponderance of the evidence. You now know the term exigent circumstances. You know a lot of legal mumbo jumbo. But my goal here was to convince you that it's easy for the reporting party. It's only trickier for the petitioner, for the cop or the DA. And if I've convinced you that it's easier, then I've done my job. So, there's a missing L over there. So I want to thank you for listening to this speed wrap here. And I want to ask you, please, to take a survey. And Jessica, if you can put that link in the chat, it's very important for me. I do this work with New Mexicans to prevent gun violence. I've done it for police officers, DAs, millions of different community groups. School. This year, we're going to be focusing on schools where students, lots of people, but this funding for me to provide this training happens because people take the survey. So please, please, please take the survey. Okay, now I'm going to give you my information, how to reach me. And I will tell you that no matter how many times I tell you this is easy peasy, when you're in an emergency situation, nothing's easy. So what you get to do by having attended this training is you get to call me up on my phone anytime, day or night, and say, should I get an ERPO? Do I have enough? Do I want to do this? I will not give you legal advice, but I will help you think through what you think you want to do to keep yourself and your loved ones safe. I don't have a dog in this fight. I just want people to stay safe. And if I thought I could take a little effort on my part and save a life, I would do it. And I hope that you feel the same way. So now it's time for questions, thoughts, concerns. What do you think, folks?
Questions? Anybody?
Go ahead.
Oh, well, don't all ask at once.
I have a question.
Go
Sheila,
for it.
so I heard you say the 10 days for the final order, but the temporary order, how quickly does that get turned around?
It should be as quickly as a police officer can walk out of the court with a piece of paper in his hand. If he's motivated, it should be directly from the courthouse to the respondents.
But I mean, the judge is not sitting there waiting for petitions. So
they're treated on an emergency basis. They should be handled quickly. They know they didn't name this extreme risk for nothing. They go to the top of the list.
Okay.
Hopefully.
So like we're talking about a day?
Could be. I mean, yes, you want it to happen as quickly as possible. That little bit of safeguard that's a little scary, the fact that the respondent doesn't know any of this is happening, gives you a little bit bigger window of opportunity, because as soon as they're served, that's when the agitation, I think, is going to really increase.
Okay. I know this law passed, a couple of years ago?
Mm-hmm.
And is everybody in the state doing this, or certain districts? Or
so we had a lot of pushback. I was working at the legislature and I heard all the hearings. We had sheriffs coming in saying the sky is falling, the sky will fall if we do this. This is not right. Their complaint was, we don't have room to store all these guns. Total nonsense, because there's not all these guns. And yeah, they have a police station and it has that has locked capacity to store things. That's utterly ridiculous. But let's just say they got it inundated. The good news is the new federal law that's hopefully going to pass, because it doesn't do a whole lot to address gun violence in this country, is about funding local authorities to be able to enact this law, to make it work, not to enact it, but to implement it, to make it work for real. So there's going to be a lot of money out there to help to overcome it. The other thing to know is that the more rural communities where the sheriffs are were the ones who said, the sky is falling, this will never work. You're not going to stop anybody. Well, that's not true, because the only places we've seen them filed and successfully used actually have been in some of the more rural places by some of the very sheriffs who opposed it. When the time comes and somebody walks in and says to you, my loved one is talking about killing himself and he cleans his gun all day long, this can happen at any minute, that officer is going to jump on it. They're going to want to get this thing done. What they've done in the past was they would just roll up on the person's house if they didn't totally agitate the respondent, the gun owner. They managed somehow to have a normal conversation with them. They would say, hey, why don't you just give me your gun and I'll hold it for safekeeping. That's what they would, small town, let me just have it, I'll keep it. And that worked pretty good, except for the fact that when the gun owner the next day said, I really want my gun, and walked down to the police station, they got their gun back because the police had no authority to hold it. If the police had a court order, they would say, I'd love to give you your gun back, but I can't. I have a court order here that says, if you want your gun back, you have to go to court and get a judge to issue that order. And there was a time recently where I think it was a sheriff tried to be the good old boy. Let me just have your gun. I'll hold on to it for you. And the guy came back, picked up his gun, and a tragedy ensued. Mm. Can you imagine how that officer feels? He thought he did the right thing. But unless you have the heavy arm of the law to keep it, you really can't can't jolly somebody out of something. It's not that not in that kind of emergency. So,
Thank
any
you.
other thoughts or concerns, or anybody else curious about what this federal law is going to do? I'll jump in with that one because I'm really skeptical.
Mhm.
When we have orders of protection, domestic violence orders of protection, the federal government has a law that says it's against the federal law to own a gun when you're under an order of protection, a state order, DV order of protection. And everybody in the legislature said, so why do we need a state law? We already have a federal law. It's because the FBI is not in the business of going to people's houses and asking for guns because there's been a domestic violence dispute. The FBI is not everywhere. Your local law enforcement is everywhere. They are approachable. You can talk to them. You can tell them what's going on. So to the extent that they're going to pass a federal law that authorizes the FBI or, I don't know, CIA, I don't know who else, to go collect guns, it's not going to happen. We have to use our local laws. For this part of it, it's a local problem. Other laws around gun violence perhaps would be more appropriate to be national laws, but firearm relinquishment really has to be local.
Oh, I have a question. I understand that this is a law and it's really meant to remove a firearm from a potential situation that may get out of hand. But on the other side, be it 10 days, if they remove the weapon, 10 days and up to a year, is there any follow-up or wraparound services for the respondent or for the family to work through a situation that came to that point?
It's not going to be via court order. That would be ideal for the judge to say, you know, if you want your gun back, why don't you go see your psychiatrist again and get back on your meds and get stabilized and, you know, go back to your program and start working, start whatever.
Yeah. Oh.
The issue is the court's not going to go there. It's going to be up to the support service for that the person already has their family or whoever else they're using. Bill, I'm going to ask you if you can mute yourself for a minute. You're back. So I wish that the court, but it was hard enough to get this bill through as it was. And many people say, well, you can't order people into treatment. I don't agree with that. I think there are times when the heavy hand of the law really inspires somebody to get the treatment. And once they get the treatment, they start progressing. Exactly. They need that impetus, but it's not going to come through this law.
Right. Okay. It may be another level that we need to follow up or try to achieve.
Right.
But
I think if we had better mental health services here, which we know are so sorely lacking, we could really make a difference in people's lives. We could really give them the service and the support they need. People don't want to be agitated, and they certainly don't want to be terrifying their loved ones. It's got to feel terrible.
Right.
But they don't know how to fix the situation. They're stuck in it. That voice is telling them what it's telling them. It's really hard.
Thank you.
Sheila, you may not have the answer to this because this is something that Richard Eads asked on the interview.
Oh, right.
And that is just simply the person who files this report will be telling sensitive information about the individual that's leading to the emergency order of protection. What are the protections on that information once it's handed over to the court? To what extent is it public?
Well, you know, I thought about it when Richard asked because I didn't know the answer. And I rarely admit that I don't know the answer. I'll always come up with something. But here's what I'm coming up with today. I think a good DA or a good cop or a good reporting party could ask the judge to seal the petition, the place where they've written out what's happened. They can't seal the order granting the ERPO. That's public. That's a public document. But I think that you can always ask a court, please, it would be so helpful if this was not made public. I have not been training people to do that, to ask that. I hadn't thought of it. But after I heard it from Richard, I am going to start talking to police and saying, do the right thing, protect this person. And maybe we need, if we ever get more than, we the training's helped. We've had, as my partner says, we've had like a 5-fold increase, but that means we went from like 1 to 5. So I'm not going to brag about those numbers. Those are not great numbers. We still have so many more opportunities to use this. We see this in the newspaper constantly. Somebody's at the school and they call up the parents and they tell them, come and get Junior. He's not right. And by the way, I'm going to go get an ERPO because I don't think you should have guns in your house right now. Junior is not in himself. He's been at the school for years. I know what he looks like when he's himself. So we see all those school shootings that had real hints of what was coming, but nobody knew how to handle it. This is a tool. And I'm going to be doing this with students all over the state. I'm going to try and get students to understand, you know what? If you see something and you say something, it can make a difference. You can get a gun out of your friend's house and keep them alive. What a miracle it would be. One kid could save one other kid. It'd be amazing. And just to not feel, we all feel so powerless right now around gun violence. I just think this is a real way to feel like I can do something.
Sheila, I think that's a great note to close this off on, because I think that's really what everybody would like to see.